Welcome to today's Federalist Society virtual event. This afternoon, Friday, November 4th, we will be discussing who decides, the questions of state power, corporate power, and originalism at stake in the Mallory versus Norfolk Southern Railway case. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. Today's discussion addresses a recurring theme for the Freedom of Thought Project, this question of who decides, which arises here with competing claims to state sovereignty and state authority over corporations. And it's especially interesting to see that, again, the thinking does not break down along conventional ideological lines, and the disagreements have even sparked competing originalist briefing in the case. Fortunately, we have Judge Katsas with us to navigate these differences and moderate the discussion. Judge Katsas is well known to many of you in the audience. He currently sits on the DC Circuit of Court of Appeals. Prior to joining the bench, he clerked for Justice Clarence Thomas, had an impressive career as an appellate litigator at Jones Day, and served in many senior positions in past administrations. As always, please note that all expressions of opinion offered today are those of the experts on today's call. We encourage our audience to submit questions for the discussion through the Q&A feature at the bottom of your screen. Note, please, not the chat feature, the Q&A feature. After our speakers have offered their opening remarks, our moderator will turn to submitted questions to direct the panel discussion. With that, thank you for being with us today. Judge Katsas, the floor is yours.
Thank you. So Mallory is a case about the due process limits on the exercise of personal jurisdiction by state courts against out-of-state corporations. Robert Mallory was a Virginia resident. He sued Norfolk and Southern, which is a Virginia corporation, for workplace injuries that arose while Mallory worked for Norfolk in Virginia. He didn't sue in Virginia, though. He sued in Pennsylvania. And if you're familiar with the Supreme Court's modern personal jurisdiction cases, you'll spot a seemingly obvious due process problem, which is that the exercise of specific jurisdiction under the modern international shoe framework doesn't work, because even though Norfolk and Southern might have Pennsylvania contacts, Mallory's suit didn't arise from them. Nor does the exercise of general jurisdiction seem to work, because Norfolk and Southern was a Virginia corporation based in Virginia, and even if it had significant contacts with Pennsylvania as a nationwide corporation, it was not at home in Pennsylvania, which is the standard for general jurisdiction under recent cases like Goodyear and Daimler. So Mallory's answer to this is to say that the framework I just laid out for personal jurisdiction addresses what happens in the absence of a defendant's consent. But they say Norfolk here did consent. Why? There's a Pennsylvania statute which says that out-of-state corporations have to register with Pennsylvania to do business in Pennsylvania, and that registration is deemed to be consent to general jurisdiction. So Norfolk and Southern chose to register. Personal jurisdiction is based on consent, and there's no due process problem with that. It's an interesting case on many different levels. Most obviously, it has implications for the balance of power between plaintiffs and defendants in suits against large corporations. Under the Pennsylvania statute, any plaintiff could sue any nationwide corporation in Pennsylvania on any claim, no matter how unrelated the suit is to Pennsylvania, so long as the corporation does some business there. And if the statute is upheld, that would seem to be an invitation for other states to enact copycat provisions. It's also an important case on themes of federalism and stare decisis, and originalism and stare decisis. So as to originalism, if you look at the briefs in the case, They are very long on historical understandings and practices at the time the 14th Amendment was ratified. And they are relatively short on freestanding policy arguments about fair play and substantial justice, which is one of the key tag phrases from the first modern case of international shoe. The parties have clearly taken note of cases like Bruin and Dobbs, and pretty much everyone seems to be expecting a due process decision driven largely, if not entirely, by history. As to stare decisis, there are those issues cut in both directions in this case. There's a lot of language in the modern cases that might tend to favor the railroad. Goodyear and Daimler are recent cases enacting a narrow view standard of general jurisdiction. And there's an argument that Mallory's theory would effectively gut a lot of modern precedents. On the other hand, there's a 1917 case called Pennsylvania Fire, which seems to support Mallory and sets up Mallory to argue originalism and stare decisis based on old practices and at least one old case. All right, why is this an interesting case? Might it be an interesting case for a freedom of thought panel? The Freedom of Thought Project takes seriously the idea that corporations may sometimes be a threat to individual liberty, and state regulation of corporations may sometimes advance individual liberty. We talked about those issues a week or two ago in connection with net choice litigation involving state regulation of big tech companies. Here, the parties agree that a state couldn't require out-of-state persons to waive constitutional rights under the Due Process Clause or otherwise as a condition of entering and doing business in Pennsylvania. That would be an obvious Privileges and Immunities Clause problem, among other things. But they may have more latitude to impose requirements on out-of-state corporations, to tell a foreign corporation, if you want to do business in our state, you have to follow our rules. And if that's the right way of thinking about the question in Mallory, there are freedom of thought issues. And maybe that makes Mallory loosely related to the Dormant Commerce Clause issues in the recent pork producers case, where California said, if you want to sell pork in our state, you have to meet our standards for humane treatment of animals, including in out-of-state activities. We've got a great panel to address these issues. They are distinguished in their own right, and they have wonderful expertise for the question we're discussing. So Sean Murata is a partner in the appellate litigation group of the Washington office of Hogan Lovells. He graduated first in his class at the William and Mary Law School, and then clerked for Judge Jane Grawl of the Appellate Division of the New Jersey Superior Court. He has substantial experience litigating personal jurisdiction issues on behalf of defendants, including in the United States Supreme Court. Among other things, he argued for the petitioner in Ford Motor Company against Montana 8th Judicial District Court, the Supreme Court's most recent decision on personal jurisdiction, and he filed an amicus brief supporting the respondent in Mallory. Steve Sachs is the Antonin Scalia Professor of Law at Harvard Law School, where he teaches civil procedure, conflict of laws, and constitutional law. After graduating from Yale Law School, he clerked for Judge Stephen Williams on the DC Circuit and for Chief Justice Roberts on the Supreme Court. Steve is one of the nation's leading academics in the fields of personal jurisdiction and originalism. And drawing on his expertise in both fields, he filed an amicus brief on behalf of himself, largely supporting the petitioner in Mallory. So with that, we thought it would make sense for Sean to present the constitutional challenge to the Pennsylvania statute, and then Steve to follow up with the defense. So Sean, the floor is yours.
Sure. Thank you so much, Judge. So yeah, as Judge Katz has mentioned, I did file an amicus brief on behalf of Professor Tanya Monister in Mallory in support of Norfolk Southern. Let me start by saying the views I'm going to give today are my own and not necessarily hers, because I know she's listening in today. The way to understand the traditional case against the Pennsylvania consent by registration provision is to really tell the history of personal jurisdiction in the Supreme Court doctrine. And it's the sort of story that we all learned in 1L civil procedure class. And it goes something like this. First, there was Pennoyer. Pennoyer relied on a set of fictions about what it meant to be subject to a state's power. And the understanding under Pennoyer was that you were only subject to suit where you were incorporated or where you had property. But that was thought to be unfair because it allowed corporations to escape suits in places where they did lots of business and the suit is related to the business that they did in the state. So what the courts did was they began to invent a series of fictions. Fictions that, for instance, by entering into a state and doing business there, you engaged in a certain implied consent to be sued on the actions that you took in the state. Then the fiction sort of went further along into Pennsylvania Fire, where if you registered to do business in a state, there was a fiction that you had agreed to be sued on all claims there. And what the court said in Pennsylvania Fire is even if the statute which is subjecting you to suit isn't particularly clear, the reality is if you sign a piece of paper appointing an agent for service of process, you sort of take your chances. You take your chances that a state court is going to interpret in a certain way, and there's nothing to complain about under the due process clause. Then you get what Justice Ginsburg calls in Goodyear the path-marking decision in International Shoe. International Shoe was supposed to overthrow the Pennoyer era and say, look, in this previous era, we had all these fictions, but the fictions were just that, fictions. They are things that courts invented because it seemed unfair that corporations were getting away with not being sued in states where they were doing wrongs to people. So what we're going to do in this decision is to lay the fictions bare and reveal the actual philosophical underpinnings that those fictions rested on, which is that, and this is the traditional tale of specific jurisdiction, that it's a quid pro quo, that if you avail yourself of the privilege of doing business in a state and the claim is arise out of or relate to that particular conduct, then you can be sued, and that's specific jurisdiction. And so International Shoe, the traditional story goes, knocked out the previous era. And the court over the next couple decades reaffirmed that. There's a case called Schaefer versus Heitner, where their question was quasi and rem jurisdiction. And there's a footnote there where they say, you know what? We have a bunch of old decisions that from before International Shoe that might be thought to bless this particular method of jurisdiction. We're not going to go through and tell you whether all of those are correct under modern doctrine, but basically International Shoe is the standard. And to the extent that they disagree with International Shoe, our previous decisions are overturned. And then there's Daimler versus Baumann, where the court lays out its test for general jurisdiction that Judge Katz has talked about. And in that opinion, they said, by the way, to the extent that we have pre-International Shoe opinions, they should not, quote, attract heavy reliance today. And in a case called BNSF versus Tyrell, the court again says, knock it off with the pre-International Shoe opinions. Really, we mean it. Stop having those opinions attract heavy reliance today. And so when you look at that historical sort of traditional 1L civil procedure story, Norfolk Southern says this is easy. Sure, Pennsylvania Fire maybe made sense in the Pennoyer era, but now that we've moved past that, this has nothing to do with modern notions of personal jurisdiction or consent. And that's, I think, the second point that comes across in the challenger's argument, which is to say that we talk about consent, but what's happening here isn't really consent in any meaningful circumstance. In a contract, for instance, you say, I hereby agree I will subject myself to the jurisdiction of this court, and it's a relationship between me and you as contracting parties. Here, it's the state has more or less imposed it as a consequence on you of registering to do business. And there's not things like unconscionability and other doctrines that we would normally impose in a consent-based regime. It's sort of similar to like the DUI cases, where many states say that by driving on the roads, you consent to having the police take your blood if they think you're driving under the influence. But what the Supreme Court has said, and I think what common sense says, is that's not really consent. That's just they imposed a consequence on you. And what the Supreme Court has said with respect to those blood draw cases is, sure, it's called consent, but it's not really consent. So we're just going to analyze it as if it's a Fourth Amendment issue. And what the challengers say in Mallory, what Norfolk Southern says, is it's basically the same thing here. You can call it consent all you want, but really you should just analyze this like a due process case. And under the traditional due process doctrines outside of consent, this isn't consent. And then finally, what Norfolk Southern says is if you look at sort of the range of the Supreme Court's personal jurisdiction cases as trying to find a decent calibration of fairness between plaintiffs and defendants, Ford Motor Company, which I had the privilege of losing 8-0, was basically saying, well, sure, we know we said in some cases X, Y, and Z, and if you took it the next logical step, you're right, Sean, but that doesn't make sense. Like, no, that's not fair. The same thing here is, look, specific jurisdiction is actually pretty robust. General jurisdiction is always a backup. And what we're trying to do is we're trying to give lawsuits to the place where it makes sense to decide them. It really does not make sense to have Pennsylvania decide this case. It has no relationship to anything in the case. And in fact, Mallory's counsel gave an interview to Allison Frankel where he said, yeah, well, the reason it was filed in Pennsylvania is because that's where our trial lawyers are located. And I mean, that's honest. And I think also the Pennsylvania Court of Common Pleas is thought of as a plaintiff-friendly forum, but it's not clear why, for instance, the people in Pennsylvania should have to do jury duty for a lawsuit that has nothing to do with their case. So if you're worried about things like forum shopping and sort of the interstate federalism of making sure that states decide the cases that should be allocated to them, you really shouldn't have these cases be going where Mallory says they should. But I think what's really fascinating about this case is sort of what it means about originalism and what it means about and how even just as an advocate, you brief cases at the court. 5 years ago, heck, when we briefed Ford, we did it the traditional way, which is that, we argued about doctrine on both sides and how the case breaks down and a little bit of policy. And then everybody had a page and a half that said, oh yeah, and by the way, our understanding comports with the original view of the Constitution. This case, and as a result of Justice Gorsuch's concurrence in Ford, where he's like, I sign on to the majority opinion, but also what are we doing here? What does any of this have to do with the original meaning of the words due process of law in the 14th Amendment? That was an invitation to the wonderful attorneys at Keller Postman who came in and said, all right, let me give you the originalist story about why Pennsylvania fires, correctly decided. And their brief is loaded up with, just historical statutes and practice and a really long appendix. And it's just not how you brief cases in the past. But now that you have a group of justices that are interested in originalism, it's something you have to really change to as an advocate. And I will say, Professor Sachs can talk more about the originalist case. I'll say what Mallory says is, look, all states had statutes like this. It was totally normal at the time of the 14th Amendment. What Norfolk Southern says is, well, there's some weirdly worded statutes, but if you actually look at the practice at the time, it was actually much closer to specific jurisdiction than it was general jurisdiction. So we really can't read very much into it. And I think it's fascinating to see two sides having that dialogue, which honestly would just be blown past. I mean, if you listen to the Ford Motor Company oral argument, I get asked originalism. I'm like, yeah, Steve Sachs has a crazy theory, but nobody's arguing that, so don't worry. Well, now people are arguing it, so you do need to worry. And so with that, I'll pass it over to Steve.
Well, thank you very much. I'm not sure the theory has become much less crazy, but hopefully it's more persuasive to many. I wrote an amicus brief in this case on behalf of myself, so I didn't have to represent anybody's views except my own and give a sense of where I think the original law comes out on this question. So if you're trying to figure out what is the law of personal jurisdiction under the Constitution, it's important to realize that a lot of Wenel classes start way too late. They start as if time began in 1878 with Pennoyer, when in fact we had a century of personal jurisdiction doctrine before Pennoyer and a whole lot of rules that were out there that we have to understand Pennoyer and its progeny in light of. At the founding, personal jurisdiction was not thought about as a due process doctrine. It was a doctrine about general and international law, and it was a doctrine about what individual sovereigns could do, and especially whether other sovereigns would pay attention. Within your own courts, do whatever you want, But if anyone else is going to pay attention to you, they're going to ask, were you acting in a way that's consistent with the general and international standards of personal jurisdiction? And what's important here is that the real issue in this case is much less a due process issue, the way that it came up after the 14th Amendment, when the federal court said, look, if you're acting without jurisdiction from whatever source, then you're acting without due process of law. But it's not as if we're sort of staring at the words due process of law until they reveal to us substantive rules of personal jurisdiction. It's really much more a question about what can states do, what can they do vis-a-vis out-of-state corporations. And that's why under modern doctrine, it's much more of a dormant commerce case than it is a due process case. And I think that that matters regardless of one's view of the Dormant Commerce Clause, because at the very least, dormant commerce is subject to congressional revision. It's subject to treaties. There are lots of ways in which dormant commerce doctrine can be revised that due process doctrine can't be. And so part of my argument in the amicus brief was to say to the court, look, if Mallory loses, it's important that he lose for the right way and not for the wrong way. And the right way may well be dormant commerce on remand and not due process. So I'll give you a quick sense as to why. So at the founding, they took essentially the Mitt Romney view of corporations. Corporations are people. They're just groups of people who, under the law of a particular jurisdiction, get to act together. So the reason why the Corleone family doesn't actually own property in its own name, but the Sierra Club does, is the Sierra Club is a corporation, and California law or whatever law incorporates them, gives those people the ability to do certain things under a common name. And that was something that you had to ask permission for. It wasn't automatic. You didn't have general incorporation statutes. States could say no. Often they would require an act of the legislature if you wanted to act with a bunch of other people under a common name. And so corporate law was very much state by state. When it came to out-of-state corporations, often by comedy under the Bank of Augusta v. Earl case, the other states would allow you to come in and do business. But they might also exact certain conditions. They might say, look, if you're going to come in and do business, you need to register, you need to agree to be subject to jurisdiction in various ways, you need to appoint agents for service of process, et cetera, et cetera. If you violated those rules and just showed up and started doing business anyway, sometimes they would let you do it, but they would say, look, at the very least, you're stopped from saying whenever anyone tries to sue you on a cause of action arising out of what you're doing here, oh my gosh, I'm not really a corporation. You can't sue me in my common name here. If you're going to act like a corporation, you have to be treated like a corporation in the courts, at least for the things that you're doing in this jurisdiction. So it created a sort of proto-specific jurisdiction that was regarded as a form of implicit consent. If you're doing stuff here, you implicitly agree to be subject to our jurisdiction for the stuff you're doing here. That was slightly different for individuals because individuals had a privileges and immunities right to do stuff across state lines. And so they didn't necessarily need the state's permission in quite the same way. And the state couldn't attach conditions to that permission the way that it could for an out-of-state corporation. But all of that was the consequence of acting without permission, sort of acting without filing the papers. When the question arose, what if you actually do file the papers? Well, then very different doctrines applied. So often states would, especially toward the end of the 19th century, say, look, filing the papers here represents consent to jurisdiction and perhaps consent to more jurisdiction than we would impose on you if you merely showed up and did business without filing the papers. An example that I give in the brief is of a landowner who posts a no trespassing sign. You're not allowed to post a no trespassing sign that says anyone who trespasses owes me $100,000 in damages. No court's going to enforce that just because you put it up on the sign. They would say, look, you're not allowed to impose that. Sure, it's illegal to trespass, but you can't pick the amount of damages. That's determined by law that you can't control. On the other hand, if you put up a no trespassing sign that also says, but I will sell you a permanent easement for $100,000, here's a box of contracts, just sign here. Courts may very well enforce that because they said, look, somebody wanted to buy the easement, they signed the contract, they filed the papers, they consented. And at that point, they took you out of the regime of what you can impose, and it became more of a question of what the other side agreed to. The similar thing happened with respect to general and specific personal jurisdiction. So when corporations were just acting across state lines without permission, generally courts would allow a state to impose only a form of jurisdiction analogous to what we now call specific jurisdiction. But if you actually signed the papers and handed them in, often courts, as in Pennsylvania Fire, would uphold a regime that said you've consented to jurisdiction for whatever the state says you consented to. And so while not many states did this, some did. And those that did were never thought to create a due process problem, because all that due process required is that they have jurisdiction under some generally accepted means of doing so, not that they comport with some specific rules of jurisdiction that are hidden somehow in the due process clause. Okay, so let's fast forward to the early 20th century. At this point, the court starts applying the Dormant Commerce Clause differently. And it starts saying that it's a dormant commerce violation for a state to keep an out-of-state corporation out. That had not previously been the rule back closer to the founding, but they start saying you cannot stop a corporation from operating across state lines. First, with respect to sort of interstate commerce, literally carrying stuff across state lines, and later even as to in-state commerce. You can't keep the foreign corporation out. Well, once that becomes the rule, it becomes a lot harder to explain why you can condition their coming in on their agreeing to various forms of jurisdiction. You can't impose anything. You can't ask them to do certain things. So how can you make that a condition of their entrance? And so you have in the early 20th century a bunch of cases that do dormant commerce review of personal jurisdiction statutes, some very like the one that's at issue in Pennsylvania here. And some cases uphold them and some strike them down, and it's sort of confused. And then it all essentially gets mooted out by international shoe. But the thing that international shoe does is that it reserves the question of consent. It doesn't reach the question of what do you do if the defendant has arguably consented to jurisdiction, as the Norfolk Southern Railroad arguably has done here. And so that's why Mallory argues that Pennsylvania Fire is still good law. It's never been overturned by international shoe or any of its progeny. All of those cases have left the issue of consent by the by. What Norfolk Southern does argue is that, okay, well, even if there was consent, it's an unconstitutional condition. You're making me give up my due process rights that I would otherwise be able to insist on in exchange for agreeing to your kind of jurisdiction. I don't think that argument quite works, because the courts have traditionally understood consent to personal jurisdiction very differently from the knowing, intelligent, voluntary waiver of other kinds of constitutional rights. It's of course clear that Pennsylvania could not say to the New York Times, you're an out-of-state corporation. If you want to sell papers here, you have to give up your First Amendment rights. I mean, everybody agrees they can't do that. And indeed, there are cases that said from the late 19th century, you can't impose as a condition that a corporation can't remove to federal court in diversity cases as a condition of doing business here. But those very same cases said it was perfectly fine to require them to consent to personal jurisdiction of various kinds as a condition of doing business here. And part of the reason is that with regard to personal jurisdiction, it's not so much the waiver of a substantive right as just avoiding the need for the exercise of a power that the state might have. So if you just show up in court, we don't need to ask the question whether the state had the power to force you to show up. You just did. If you sign a piece of paper saying, I agree to show up, we don't need to ask the question, did the state have the power to force you? You just did. And so a lot of the unconstitutional conditions doctrine is designed for areas of the Constitution that don't look very much like personal jurisdiction, and indeed would be very strange if we tried to extend them to personal jurisdiction. The last thing I want to point out, to return to what I mentioned earlier, in my view, this is really a dormant commerce case. It's really a question about whether Pennsylvania can require states to sign a piece of paper if they want to do business in Pennsylvania, much more than a question of whether it violates due process. The due process argument is pretty much satisfied. The problem is whether Pennsylvania could have made them stay out, or whether it can make them sign the piece of paper if they want to come in. And what's important about that distinction, again, is that Congress and the treaty power can both override what would otherwise be dormant commerce doctrine. And indeed, there are lots of originalist critiques of dormant commerce doctrine. It's not clear dormant commerce doctrine really exists. But if it does exist, at the very least, it's subject to congressional and treaty override. And that might be very important if we have judgments from other countries that our treaties might require us to respect, or if Congress wants to impose its own regime. It might matter a lot which way the court resolves this question. And in my view, it's really more of a dormant commerce issue than it is something under the 5th or the 14th Amendments.
We are right on time, so there's plenty of time for the panelists to offer any rebuttal. Sean.
Yeah, so I think actually Professor Sachs drives at something that I think is fundamental to this case that isn't, I think, given the attention maybe it should in some of the briefing and in some of the back and forth, because it really, and this is what our amicus brief was about, which is, what do we mean when we say consent? Because I think what Professor Sachs is getting at is that the consent we're talking about in personal jurisdiction is not the consent we're talking about when you say consent to search my car, consent to not say things that I would otherwise have the right to say, so, those rights are generally under this sort of knowing, voluntary, and intelligent standard, whereas the consent for personal jurisdiction is more in the penumbras. It can be implied, it can be more ambiguous. The tie isn't going to the runner in the personal jurisdiction sense. And I think from certainly the amicus brief we filed perspective, and from my perspective, if it's not the same kind of consent, then it's really not consent, because the force on the Mallory side is that, look, you can agree to lots of things. So you can agree to give up this right too. But I do think the concern is that if you think of this as robust consent, then what else can states do as a condition of doing business? And I think it throws you right into the middle of some of the culture wars we have today. Can Florida say that if you are an out-of-state social media corporation, you are going to agree to, a free speech regime and not engage in certain censorious practices, notwithstanding perhaps your First Amendment right to moderate your platform in a certain way? If you're going to do business in California, does that mean that you have to subject yourself to certain conditions, such as, for instance, state inspectors can come onto your property at any time and look for what they view as regulatory violations? I think it is quite troubling, the notion that we are now going to use the registration power as a hook to get our claws into corporations, given that corporations are now quite the political football. And the notion of what that means for consent and what we think of when it comes to consent, if there's sort of its second order consent in the world, then it ought to be explicit. And I think once you make that explicit, I think, in my view, that's where you just say, well, this is all like the other due process cases where you're just imposing the state's will on someone. And we don't think, for instance, that Pennsylvania could have a statute that says, if you do a lot of business here, therefore you're subject to general jurisdiction, because that's what we think is fair. I mean, you'd have clear notice, but that would just be contrary to the general jurisdiction case law. So meanwhile, saying, well, you signed a paper, and which you have to do if you want to do business here, I don't think it should be any different. And I do think also it presents one of those questions of what happens when you have an originalist system that's only originalist in part, because as I think Professor Sachs mentions, this originalist notion of personal jurisdiction sits very awkwardly against originalist non-originalist views of, say, the Dormant Commerce Clause. And I'm not saying there aren't originalist views of the Dormant Commerce Clause, which we saw in the pork producer case, but sort of the traditional originalist case against, say, the Dormant Commerce Clause, where you say, well, all right, we have one set of doctrine if we're going to make it originalist, and how it interacts with our non-originalist doctrines. How do you make that fit together? I do think you can think of this as a Dormant Commerce Clause case, but I view it much better as just a state try to impose its will, and just because it's using the fiction of consent, because it's not the robust traditional consent, then we haven't really actually solved the problem of consent at all. We're just saying that states have a different set of powers in this area. And if that's your view, then you want to justify it on that ground, not on the ground that somehow a corporation has agreed to what's happening to it. I think there's also just a broader concern of, if the mugger walks up to me and says, your money or your life, I have clear notice and an understanding of what my choices before me are. As the old Henny Youngman joke goes, I'm thinking, but it doesn't But when I hand over my money to the robber and he runs away with it, it's not as if he's doing so with my consent, because I have made a decision in the face of a clear choice being put to me. In the same way, asking corporations to say, either do business maybe only in your home state or nowhere, then really you're asking a corporation more or less to commit corporate suicide. And that's not a meaningful choice at all, because although only some states have taken the choice to impose consent by registration according to their own state statutes, there's theoretically nothing that prevents all 50 states from doing it. So if you're saying that all states can do it, what you're saying is either accept being sued anywhere, or just don't do business outside your home state if you're not willing to do that. And then what that means for questions of allocating cases to their appropriate spheres and everything else, I think comes right back to the fore.
Steve?
So what I would say there really is it all depends on how we understand the state's power to exclude. It's all about the right to exclude. If states at the founding had the right to say, look, we don't want corporations, we don't have to grant any corporate licenses at all, they could do that. So at what point did they lose that power? What was the first year in which a state lawfully could not say, we don't want any corporations here? It's hard on an originalist basis to pick a year and point to it. It's not clear that anything has happened since. So the question is, okay, well, if they have this power and they've never lost it, why can't they exercise it in this particular fashion? So right now, under dormant commerce doctrine, that's thought to be a problem with commerce across state lines. I'm not sure that's entirely true, even if you think dormant commerce is a real doctrine, even if you think the commerce power is in certain ways exclusive. It's not clear that sort of corporate form is part of that. But there might be other options. So for instance, Congress under the full faith and credit clause, it has a power to prescribe the effect of state registration in another state. So it might be able to say, look, as a matter of federal law, we're giving you the right to operate across borders under full faith and credit and so on. They haven't done that because the court has sort of done their work for them and sort of creating new doctrines about where states, which corporations can operate where. But it's not as if the legal system is entirely without any tools to figure out what kind of regime of out-of-state corporations operating in other states do we want to have and who should be able to regulate them as to what. The other point I want to note is that it's generally true when it comes to jurisdiction and also even to related things like forum selection clauses or arbitration, that we don't tend to require the sort of knowing, intelligent, voluntary standard that we would apply for, let's say, a guilty plea in a criminal proceeding. You can sign an arbitration agreement that's on page 93 in small print. You can sign a forum selection clause that's buried somewhere in the agreement and everyone thinks, yes, that's fully effective, even though it's essentially depriving you of rights, maybe even constitutional rights on which you would otherwise have had the ability to stand. And it seems that personal jurisdiction is very much of that form. We have rules, for instance, that a state court can say anyone who files a claim in this state court is liable for a counterclaim, or is amenable to jurisdiction for a counterclaim. And that wouldn't be the case. It's not because you sort of came in and signed a form and wrote it in blood, I hereby consent to being sued. But we just understand those are the rules of the game. And in particular, when you're filing pieces of paper that have formal effects, the courts generally treat that very differently from just sort of driving on the road or just doing business. We're very reluctant to say, anyone who drives on the road hereby signs over their firstborn children. But on the other hand, we are willing to say anyone who signs a contract, that has a certain effect under the law is bound by that kind of effect because these are formal documents and you guys have lawyers and you're able to figure out what the consequences will be for you. So to my mind, the question facing the court is really less about what kind of regime do we want for corporations acting across state lines, and more, which doctrines govern that? And I think the answer clearly in this case is not the due process clause, which at most just requires that states have jurisdiction, not that it prescribes some secret list of jurisdictional principles, but rather dormant commerce or whatever Congress has done along these lines that would actually give corporations the right to operate across state lines. If, for instance, Pennsylvania had said, we will just offer, this bright, shiny nickel to any corporation that wants to sign up for general jurisdiction in Pennsylvania courts, I don't see anything in the Constitution that says they can't do that, or that the corporations, agreeing to take the nickel would somehow be invalid. And at that point, we're really just haggling over the price. So it's really just a question of what can Pennsylvania keep out? What benefits can they confer? And is that consistent with our dormant commerce doctrine or with whatever else Congress might do under that heading?
Okay, let's go to question and answer. So I'll pose one or two, and then we have a couple so far from the field, from our audience. All right, so Sean, you expressed a view that international shoe preempts the field and cuts off all the old clunky formalistic rules that that just, you can't argue anymore that any of that survives. And there is a lot of language in the modern cases supporting that, but there's also Burnham, right, which is a Scalia opinion which upholds tag jurisdiction, right? Someone who has no connection to Pennsylvania is driving on the Pennsylvania Turnpike and stops at a rest stop and gets served, and that's good enough for personal jurisdiction. And Justice Scalia says, I don't really care about fairness because this was the rule from time immemorial. Why isn't that, why doesn't that allow Mallory to make the same kind of argument here for the registration statutes?
Yeah, I mean, that's a great point, Judge. And I think, one of the, in my sort of neat 1L civil procedure story I told at the very beginning, Burnham is sort of the bump in the road, or at least the anomaly that everyone has to explain. In my traditional telling, though, Burnham is actually pretty helpful for the Norfolk Southerns of the world. And this is why, because in Justice Scalia's plurality opinion for the court, he says, look, natural people, the rule was always if they got you with service of process, that's it. But he also said, corporations are kind of weird because they don't fit neatly into that framework. Because of course, Norfolk Southern Railway doesn't drive on the Pennsylvania Turnpike, and a process server can't slap Norfolk Southern with the summons, because Norfolk Southern isn't a person, it's an idea. I mean, Norfolk Southern is the friends we made along the way. So the law created the various fictions, Justice Scalia says, about the implied consent and so on, and says exactly what all the other cases said, which is that international shoe got rid of the fictions. So in my view, Burnham is pretty much in a line where it says, when it comes to corporations just aren't subject to these exact same rules the way individuals are. I think add to this one of the arguments that Norfolk Southern makes, and honestly, this is just everybody sorting through the giant historical appendices and seeing who's right, is they say it actually wasn't the view since time immemorial that corporations could be subject to general jurisdiction. What they would say is there's some statutes that suggest maybe, but they weren't interpreted that way. And we have to understand the statutes, but in the light that the state courts were interpreting them. And then, states had different views. And so to bring this back to cases like Bruin, where, there was the argument that, well, certain states had certain restrictions on carrying guns, and the court said, well, some of them did and some of them didn't, so we're not going to put heavy weight on it. I think what Norfolk Southern would say is actually the historical practice is not as uniform as the Mallorys of the world claims it is, such that you can't say that it was so set in the time of the 14th Amendment that you would carry this across, particularly when it comes to general jurisdiction. I mean, I think maybe Norfolk Southern would concede that there was enough of a view that said registering could create specific jurisdiction for claims that arise out of the actions that occur in the state, but not for this broad general jurisdiction. Because of course, what general jurisdiction means is any claim by anyone, anywhere. So not just Mallory, who, you think, well, Virginia's close enough and it's a big railway. But like, if you're somebody in Germany and you're upset about the train ticket you bought because you feel like you overpaid and you have a contract claim, you can bring that in Pennsylvania too. And the traditional response is, well, there's forum nonconveniens and venue selection, but those are all state law doctrines. I mean, Pennsylvania doesn't have to have a forum non-conveniens doctrine. And so if the goal of the 14th Amendment and due process law is to say there are some things that states can't do, then you shouldn't be at the mercy of state-created doctrines about forum non-conveniens. But I would say the traditional complaint, and you saw this in Justice Sotomayor's dissent in Bristol-Myers Squibb, is why is there tag jurisdiction for individuals but not corporations? And part of the answer is, well, because corporations aren't things that can be tagged. But that certainly has been a philosophical disagreement around tag jurisdiction for a long time.
Steve, any thoughts? Or
Sure. So the one thing I want to note is that it's certainly true that as a matter of sort of implicit consent, what happens to you if you just show up and start doing business without filing any papers? The vast majority of courts said that's sort of specific or proto-specific jurisdiction only. There's a little bit of disagreement on that. Cardozo went the other way in New York in the early 20th century, but in general, they said if you just show up and do business without filing any papers, it's just sort of you're only amenable to jurisdiction on the stuff you were doing in that state. But when you actually filed something, the regime was very different. So a number of states, typically they don't want general jurisdiction over everything because they don't want their citizens to have to do jury duty over, things that have nothing to do with them. But sometimes they would say, for instance, any claim by a resident, whether it arose here or arose somewhere else or had anything to do with the state or not. So if you're a Pennsylvania resident and you took the Norfolk Southern in Virginia and got injured, you can come back to Pennsylvania, and regardless of whether they have Pennsylvania contacts, under those statutes, you could sue them there and the courts would be open to you because they had registered to do business and that's what they'd signed up for. So that would be excluded under modern rules like Daimler, if Daimler applied, and under modern rules like Walden, because you're not, you didn't have any contact with the forum, only with a forum resident. But it was pretty clear back then that that was something that states could do. And so the way that the courts understood this area of doctrine prior to international issue would have allowed states to say, we can stop you from coming in, and if you're going to come in and you're going to file these forms, this is the legal consequence of doing so. So the real question now is twofold. One, do we expand international issue to stuff that it sort of explicitly left alone and didn't talk about because the sort of principles of international issue are broader than the case itself? Or do we say that sort of as a matter of dormant commerce, this isn't something Pennsylvania can do? This isn't a demand that they can make of out-of-state corporations. I think both of those are complicated moves on originalist grounds. And, it's certainly possible that the court would be attracted to them as a matter of policy. I am attracted to it as a matter of policy. I don't want a regime where everybody's suing for everything in Pennsylvania. But it may be that the right person, the right entity to do something about that is Congress and not the courts, because Congress can actually internalize all of the different interests that are going on here and can come up with whatever regime under the full faith and credit clause it wants for what being a corporation in one state gives you the right to do in other states without having to ask permission.
so let's talk about limiting principles, which you just mentioned, limiting principles and halfway originalism. So the argument is, we should really gut a lot of modern understandings of the due process clause as incorporating rules of personal jurisdiction, but don't worry too much about that because there's a backstop, and the backstop is the dormant commerce clause. Dormant commerce clause is maybe not the most historically grounded doctrine in the Constitution. And if you're trying to pitch this case to Justice Thomas or maybe Justice Gorsuch, that might not hugely work as a fallback doctrine. So, for non-robust originalists, if we get rid of due process and don't want to go down the road of dormant commerce, what are the limiting principles? Is there anything left other than Congress?
If I can jump in, what I would say is,
this is mainly for you.
Oh, sure. What I would say is the first rule of holes is that if you find yourself in one, stop digging. So there's a lot of non-originalist precedent out there. There's a lot of, weird stuff going on in the US reports. But if you come to a case and it poses a question presented, and the question presented is, does the due process clause of the 14th Amendment prohibit X? And the correct answer to that question is no. You should say no. And if there are other issues that will then be presented in the next case, you can resolve those on originalist grounds too. But there's no sort of, I haven't seen any principle in the original law of the United States that allows for a court to say, well, we've messed up somewhere else, so we're not going to enforce the laws that we ought to here. And it may well be that if the Dormant Commerce Clause doesn't actually impose any limits on Pennsylvania, if it has a complete right to keep out foreign corporations, then yes, you would have to turn to Congress to do something under its powers to make them let foreign corporations in. But that shouldn't seem all that surprising for an originalist, because all the time there are issues that the courts can't do on their own, and only the political branches can get the policy result that one thinks is best. It's this case with tax policy as much as personal jurisdiction, perhaps. So we've become accustomed to the idea that the courts sort of write personal jurisdiction doctrine under international shoe. But if that's not actually how it's supposed to work, then it seems appropriate for a court that's aware of that to say, like, no, that's not what we're going to do here. We're going to try and apply the actual law and not sort of the best patch up of that law we can, given a whole bunch of other precedents out there.
John?
Yeah, I mean, I agree with your comment, Judge Katsas, because I think one thing where I approach this conversation differently is I primarily think in my world as an advocate, where you're trying to talk to the court and you use sort of all the tools in your toolbox. And what's interesting about the Dormant Commerce Clause fallback is that when you're counting the votes on the court, the people that if you're saying, well, originalism isn't with us, but Dormant Commerce Clause is well, the people that are probably most appealed to by originalism are probably also the people that are least going to be interested in a Dormant Commerce Clause fallback. So it's not clear if you should, give up the ship on the first one and make the pivot if you're not also going to find solace there as well. I mean, I think one thing about this case is it says a lot about what are you going to do about the International Shoe Project. I mean, the point of Justice Gorsuch's concurrence in the Ford case is he thought, have we just sort of gone astray these last couple decades? And there's certainly the argument to be made that this is all consistent with International Shoe because it's consent, and consent is a different box. And so it just becomes kind of the next Burnham, where it's like, sure, there's this great little story that runs across, and then there's a weird pull off that's a separate doctrinal box. But I do think at some level, it's about saying, like, do you think the court has just kind of been wandering in the wilderness, coming up with a bunch of policy-based rules for personal jurisdiction where you can say, well, the results in each case make sense, but we haven't really discerned out the rules from it. So we ought to start doing something new and maybe just throw this back to Congress or something else. And I mean, I do worry that what we're then, I think we at this point have arrived at a decent calibration of interest between plaintiffs and defendants, and cases basically go where they should. I'm afraid if you do this and you blow it wide open, you're then just going to upset the balance, and you're going to start getting results that don't make any sense at all. And then it's all going to become a bunch of procedural fencing on an issue that, at least the court to this point have thought, should be relatively easy to figure out at the beginning of the case without prolonged litigation. Because it's all just going to become epicycles of forum selection clauses. I think there's also a concern that are some corporations in a world where Mallory wins just decide not to register anymore. Because in some states you can get away with it because maybe they only impose a fine, or maybe you can't bring lawsuits in that state. Like, that's annoying, but you can probably manage your risk. You can pay the couple $1,000s, or you can structure your own contracts so that you have forum selection clauses somewhere else. But in some states, it's like the attorney general can come shut you down. And so in those cases, like, are you going to have to litigate whether you were quote unquote doing business for purposes of your registration statute in a lot of cases? And during the Pennoyer era, that was not a fun time. I mean, Learned Hand has a decision out of the Second Circuit where he says the cases are morass. Is having an office in the state enough? Maybe, but maybe not. Or is having contracts in the state? Maybe, but maybe not. And you just did this long set of considerations as to what constituted doing business in a state in the Pennoyer era. And that's what we're going to go back to, because states are, I don't think corporations are going to go quietly into that good night and keep registering. I think they're going to fight back. And then we've just created a whole new swamp that I think is going to be very hard to get out of. So I don't think it's just, I think always there's going to be a response to these cases. And I don't think the response to a win for Mallory is all corporations are going to say, guess Daimler's a dead letter now. We got to go back to being essentially subject to general jurisdiction everywhere. I mean, what people like I are going to start doing is say like, well, maybe we should start thinking about not registering in some states and give that a whirl. And that's not going to be good for anybody either.
We've gotten a handful of questions from our audience about extraterritorial application of state law. So let me just tee that up. Mallory is a case about the state's adjudicatory authority, the ability of the Pennsylvania court to hear this case. There's a related but different question about whether Pennsylvania could apply its own substantive law to the case, as opposed to having the Pennsylvania court apply Virginia law, because everything relevant to the case happened in Virginia. So let me ask both of you to comment on what, if any, constitutional limits there are on a state's ability to apply its own law extraterritorially, just as a general matter. And then more specifically, this has come up in some of the questions, could you comment on the relationship between what's going on in this case and the extraterritoriality questions that were bandied about in the Dormant Commerce Clause context in the pork producers case a week or two ago?
Yeah, I mean, I hate to post up against the conflict of law scholar here, but I do think, sort of under traditional notions of conflicts of law, Pennsylvania would probably apply Virginia's substantive law. Now, of course, that's not a problem in a sense. I mean, the Supreme Court has said personal jurisdiction is not the same thing as choice of law. There is a due process limitation on choice of law, but it's looser than personal jurisdiction. It has to be pretty egregious before a state's choice of law principles will be found to violate due process. Although maybe it would trip this limitation here if Pennsylvania were to apply its own law. And so, it shouldn't necessarily trouble us that personal jurisdiction and choice of law point in different directions. Though I will say in the Ford case, the court had said previously, it's not sort of like where the case makes most sense. But in Ford, the court kind of suggested, well, maybe it is where the case makes the most sense. But I do think there's an interesting question that's embedded in this that I think came up in the question, which is you can also agree to choice of law in your contracts. So is it the same kind of consent and that we find on personal jurisdiction? In other words, if Pennsylvania said by registering to do business, you not only agree to general jurisdiction, but also that Pennsylvania law will apply to all of your disputes in this state? I think there's a decent argument that if you're going down that path, it may be the same consideration. But I don't know, Steve, I'll throw that to you.
Thanks. I would certainly agree with what you said thus far in the sense that, right now the doctrinal constraints on choice of law are quite loose under Allstate and Phillips Petroleum. They still probably would stop Pennsylvania from applying its own law here because everybody agrees that everything relevant to the case happened outside Pennsylvania. And additionally, the constraints on choice of law clauses are quite loose. And so if they really did sign a choice of law clause that said we're going to select Pennsylvania law for everything, it might very well be something that Pennsylvania could carry out. And again, the real question would be, is this something that Pennsylvania can demand as a condition of coming in? And that really focuses attention on the question, well, can they keep you out? Could they have said no? And so there's sort of no way to figure that stuff out without having a theory of, can states keep out out-of-state corporations and why or why not? And so if that's not going to be a dormant commerce theory, it's got to be some other kind of theory, such as privileges and immunities or full faith and credit. Like there has to have some explanation of why would Pennsylvania, which otherwise can govern, who can operate on their territory, why would they be stopped from saying, no, look, you can't operate on our territory unless you do X and Y and Z and agree to the following things. again, that's why I think a lot of this is just the consequence of Congress falling down on the job. I think their powers under the full faith and credit clause are pretty extensive. And if they wanted to regulate all this stuff, they could very easily. And maybe that's what happened. I mean, like all the corporations that are suddenly worried about being sued everywhere would just go hire a lobbyist and they would get some language written. And you know, it's not impossible. The further question is raised about sort of the pork producers case, and you know, how do we understand the place of dormant commerce generally? I really haven't come to rest on what I think dormant commerce is all about, the extent to which there really is, you know, anything exclusive in the actual commerce clause that would prevent a state from regulating. Normally, you know, if New Jersey just said it's illegal to go more than 55 miles an hour in California, there's not anything that's obviously commerce among the several states in that. It just seems like the sort of requirement that everyone would ignore. And so maybe the real issue is much more about federal court choice of law and about, you know, the Claxon rule that sort of bound federal courts to state choice of law rules, and much less issues of pure dormant commerce.
The red light is on, but since we don't follow the red light in the DC circuit, I will invite you briefly, both of you, to make any final comments that you want.
Sure. I'll start by just saying that I think what our conversation shows, it's all connected, that once you start sort of pushing on one side on originalism, you start realizing that there's a whole bunch of related doctrines. And I think, you know, that points a lot of the way to the halfway originalism point, which is, you know, do you fix one area knowing that you've sort of left all the other areas in disarray? And I think that's going to be a question that's confronting the court. I think also there's just a more basic question as to whether, like, you know, the Penoyer International Shoe tale is a powerful one. It's the one that everybody learned. And to tell like all the practicing lawyers in the world that like basically what you learned turns out is not right. And I think you can massage it and there are ways you can write it to keep it more limited. But I do think there is just a deeper question of like, you know, look, Professor Sachs' bottom line is that International Shoe is wrong and up with Penoyer, and that's fine. But it really is saying a lot about the world of civil procedure and what Mallory is all about. So that's why I think Mallory is this term sleeper case, because it does at some level seem like to be a kind of boring question about where corporations can be sued, but it's also like deep questions about our civil procedure system and how we think the courts interact with it and what the court's role is in building out due process law in a way that's really fundamental. And maybe the court will never address that because there are ways around it, but I think those are the questions that lie at the core of it. So it's really good to be having these conversations and to bring that out to the fore.
Steve, you get the last word.
Thank you. I think, you know, what I would really say is that the way the courts have to handle this is one case at a time. You know, the courts don't have a blue pencil power to write stuff in or take stuff out of the Constitution. They can only follow what they've got. And if we've got a sort of confused mess of non-originalist precedent and we're not sure what to do, all you can do is sort of the right thing in the case that's before you. And here, especially given that stare decisis arguably is in favor of the old rule, you know, that's what Pennsylvania Fire says, and Pennsylvania Fire has never been overruled. It seems that the easiest thing for the court to do is answer this case, say that there's no due process problem, and, you know, deal with the other cases when it gets to them. Sufficient unto the day is the evil thereof. But thanks very much.
Thank you.
Thank you so much.
I actually misspoke. This is a freedom of thought presentation, so it is Alita who gets the last word.
Thank you, Judge, and thank you, Sean and Professor Sachs. This was, I think it lived up to some very high expectations that we all had for this conversation, and I would encourage our audience to be listening on Tuesday morning when this case is argued. We will, I think, all be listening attentively and may have some follow-up programming to synthesize the arguments. Until then, I do want to thank, on behalf of the Federalist Society, our panelists, moderator, for the benefit of their time and expertise today, and thank our audience for joining and participating in this event. I think it speaks well of our circle that we had really high attendance for what at least appears to be an obscure jurisdiction case. We welcome listener feedback by email at info@fedsoc.org. As always, keep an eye on our website and emails for announcements about upcoming events. Thank you all for joining us today. We are adjourned.